Welcome to the Deep Dive, where we sift through a vast ocean of information to extract the essential insights you need to be truly well-informed. Today, we're setting sail into the complex yet absolutely indispensable world of maritime law. Think about your everyday life for a moment. That morning coffee you're sipping, the microchips powering your phone, the clothes you're wearing, or even the raw materials that built your car. Almost everything we use, consume, or rely upon has, at some point, traversed the unpredictable expanses of our global oceans. It's truly staggering to consider the sheer volume.
It absolutely is. I mean, this colossal movement of goods, this very backbone of global commerce, isn't some chaotic free-for-all on the high seas. It's underpinned by an often unseen but utterly crucial legal framework, maritime law. Without it, the world's oceans would be, a realm of endless disputes, unclear liabilities, and ultimately a complete breakdown of trade. It's the silent engine that ensures commerce flows smoothly, liabilities are clear, and disagreements can be resolved fairly and efficiently, allowing everything from your coffee beans to those microchips to reach you.
And our mission today is to give you a true shortcut, helping you quickly become well-informed on the critical facets of this vital field. We've pulled together a comprehensive stack of sources, from weighty academic treatises to international convention documents, to extract the most important nuggets of knowledge and insight specifically tailored for you. Our mission is to unpack this intricate web of rules, conventions, and practices that govern shipping and global trade.
Yeah, and that's no small task, because one of the inherent challenges in international trade is the sheer potential for conflicting legal systems. Imagine a single ship loading cargo in one country, then transiting through the waters of several others, and finally discharging its goods in yet another. Each of those nations could, in theory, apply its own different domestic laws to the voyage. Maritime law steps in precisely to try and achieve uh, a uniform liability regime. This uniformity isn't just a legal nicety. It's absolutely critical for merchants, buyers, and insurers worldwide. It allows them to assess and manage legal risks predictably,
Mhm.
which in turn directly impact the cost of trade for all of us, from the largest corporations to the individual consumer. It's about bringing order to a truly global enterprise.
Okay, let's unpack this by starting at the very core with bills of lading. These are truly fundamental documents in maritime commerce. When you imagine shipping goods across vast oceans, the bill of lading is what legally underpins that movement and provides crucial protection for everyone involved in the supply chain: the sellers, the buyers, and of course the carriers.
That's right. A bill of lading, often shortened to BL, is far more than just a piece of paper. It actually serves a triple function, each one absolutely vital to the smooth operation of international trade. First, and perhaps most intuitively, it acts as a contract of carriage.
Right, the agreement itself.
Exactly. This means it embodies the specific agreement between the shipper, the party sending the goods, and the carrier, the party transporting them. It lays out all the terms, obligations, and conditions for moving those goods from the port of origin to their destination.
And secondly, it's a very practical function, a receipt for goods. When the carrier takes possession of the cargo, the bill of lading serves as an acknowledgement that the goods have been received. Crucially, it often indicates their apparent condition. If you hear about a clean bill of lading, it means there's no clear statement noting that the goods were in poor or damaged condition when the carrier received them. This is a significant detail for the buyer because it implies the goods were received by the carrier in good order, shifting the burden if damage occurs later.
And this leads us to its third and arguably most crucial and ingenious function. It's a document of title. This is where the bill of lading truly stands out and becomes more than just a logistical document. Possession of this specific piece of paper can actually transfer ownership of the goods it represents. Imagine valuable goods floating on the ocean, weeks away from their final destination. With the bill of lading, those goods can be bought, sold, or even used as collateral for financing while they're still in transit. This makes it a negotiable document, a cornerstone for modern trade finance.
So it's not just a fancy receipt, it's practically the goods themselves in paper form, enabling a whole level of financial transactions that simply wouldn't be possible otherwise. That's a truly powerful concept. What about mates receipts? How do they fit into this picture? Are they similar to bills of lading?
That's a great question, and it's a common point of confusion. Mates receipts are, well, they're provisional documents. They're typically issued when goods are initially received by the ship, often as they're being loaded. They'll generally note the apparent condition of the goods at that specific moment, like a preliminary checklist. However, it's absolutely critical to understand that a mate's receipt is not a document of title.
Ah, okay, not title.
Exactly. It's essentially a temporary placeholder, a simple acknowledgement of receipt. Once the entire loading process is complete and verified, these provisional documents are replaced by the formal bill of lading, which then assumes its full legal weight and functions, including that critical role as a document of title, which the mate's receipt can never fulfill.
The negotiability you mentioned earlier, where goods can be traded while at sea, is central to how global trade finance works, right? I imagine this function has been shaped by specific laws over time.
It absolutely has. The ability to transfer title while goods are in transit is fundamental for financing global trade. It allows banks to lend against the cargo, and it enables goods to be sold multiple times before they even reach their final destination. This process is deeply influenced by national and international laws. For instance, in the UK, the Carriage of Goods by Sea Act of 1992, building on its 1924 predecessor, significantly impacts how this negotiability functions. And in the U.S., the Carriage of Goods by Sea Act, or COGSA, enacted in 1936, adopted many aspects of the earlier Hague Rules, further shaping the landscape of negotiability and carrier liability. These acts aim to balance the rights and responsibilities of all parties involved.
Right. Trying to find that balance. Now, here's where it gets particularly interesting and can trip people up. The impact of charter party bills of lading. How do these differ from a standard bill of lading that's issued for individual parcels of cargo?
This is a nuanced but incredibly crucial distinction in maritime law. When a bill of lading is issued under a charter party, which is essentially a contract where an entire vessel or a significant part of its carrying capacity is hired out by a charterer for a specific period or voyage phase, and that bill of lading remains in the charterer's hands, it's initially viewed as simply a receipt for the goods.
Just a receipt at first.
In that specific context, yes. It's not considered a contract of carriage in the traditional sense between the owner and the charterer, and therefore it's not directly subject to the U.S. COGSA in the same way a standard bill of lading would be. It's more like an internal document between the parties who have already entered into a larger charter agreement.
So it starts as just a receipt for the charterer, but then it transforms once it leaves their control. That sounds like a legal chameleon.
Precisely. The moment that bill of lading is transferred to a third party, for instance, a consignee who is receiving the goods but wasn't part of the original charter party, it undergoes a legal metamorphosis. At that point, it transforms into a full-fledged, independent contract of carriage between the carrier and that third-party holder, and it does become subject to laws like COGSA. This transformation is critical for establishing the legal relations and liabilities between the actual carrier who issued the bill of lading and that third-party holder, especially in complex shipping arrangements where a vessel might be chartered out multiple times or a cargo is sold while at sea. It ensures that the ultimate receiver of the goods has a clear contractual basis for their claim against the carrier.
That's a vital detail for anyone navigating these waters. Okay, to round out our discussion on bills of lading, let's talk about some essential clauses we often find within them. First, the identity of carrier clause. What does that do for clarity in a complex shipping chain?
This clause is designed specifically to remove ambiguity about who the actual contractual carrier is. In global shipping, it might not be immediately obvious if the true contractual party responsible for the carriage is the ship owner themselves, or a time charterer, or even a voyage charterer. This clause clarifies that crucial point, which is paramount for determining precisely who can be held liable in the event of a breach of contract or a cargo claim. It provides a clear legal target.
And the law and jurisdiction clause. This seems like it would be foundational for avoiding disputes, ensuring predictability in a global context.
It is, and it's incredibly important, almost like a legal GPS, you could say. This clause provides certainty by stipulating which national law will govern the contract and, just as crucially, which specific court or arbitration body will have the authority to adjudicate any disputes that arise under the bill of lading. Without this clarity, parties could end up in extremely costly and drawn-out conflicts just trying to figure out where and under what law their disputes should be heard, potentially leading to parallel proceedings in different countries or unenforced judgments. It's about preempting conflict by agreeing on the rules of the game up front.
Finally, we have the both-to-blame collision clause. That sounds rather dramatic, implying shared fault.
It can be. This clause addresses a very specific and unfortunately not uncommon scenario. What happens if two ships collide and both are found to be at fault? In such cases, if your cargo is on one of those vessels and your carrier is found to be partially to blame, this clause stipulates that you, as the cargo interest, must contribute proportionally to the overall damages caused by the collision. Its purpose is to protect ship owners from bearing sole responsibility for cargo damage when another vessel shares the blame. It's a risk allocation mechanism designed to ensure a broader sharing of liability in these complex multi-party scenarios, reflecting the principle that fault should be shared where it lies.
Okay, moving on to our next chapter, we dive into the global framework, international conventions on carriage of goods by sea. You mentioned the challenge of conflicting domestic laws earlier. Is that what truly drove the creation of these international conventions?
Absolutely. It's the fundamental driving force. The core reason for these international conventions is precisely that desperate need for uniformity. Imagine trying to conduct global trade. If every single country had wildly different rules for carrier liability, different time limits for bringing claims, or even different definitions of what constitutes a package for liability purposes, it would be an absolute nightmare.
Yeah, chaos.
Total chaos for global merchants, for insurers, and for carriers themselves. These conventions, therefore, are international attempts to harmonize those conflicting domestic laws, providing a predictable liability regime that helps everyone assess and manage legal risks more effectively. And this predictability isn't just a legal convenience. It directly lowers the cost and increases the efficiency of international trade for everyone, from multinational corporations to small businesses.
So it's all about predictability and setting a baseline. Let's trace the evolution of these rules, starting with the Hague Rules of 1924. How did they come about, and what was the problem they were trying to solve?
Well, the Hague Rules were born out of significant efforts to standardize bill of lading clauses. Prior to their existence, carriers would often insert numerous exemption clauses into their bills of lading, which were quite unfavorable to cargo interests, often leaving them with little recourse if things went wrong. There was a desperate need for a compromise, a balance between the interests of powerful ship owners who wanted minimal liability and cargo owners who sought greater protection. Early attempts, like the 1882 Conference Form, laid some groundwork, but the Hague Rules were the first major international attempt to standardize this by setting minimum liability standards that carriers couldn't simply contract out of. It was truly a first step towards global harmonization.
And what was their initial scope? What did they cover in terms of geography and types of cargo?
Their scope was initially quite narrow, applying only to the period from the time when goods are loaded on to the time they are discharged from the ship, what's often concisely called tackle to tackle.
Oh.
This means the carrier's responsibility under the rules didn't extend to the periods before loading or after discharge, only when the goods were physically on board the vessel and under the ship's tackle. Notably, they also explicitly excluded deck cargo and live animals from their coverage, assuming these were inherently more exposed and higher risk items that needed separate agreements.
What about carrier liability under these rules? Was it strict, or were there many ways for the carrier to escape responsibility?
Under the Hague Rules, the carrier has certain implied duties, primarily to provide a seaworthy ship before and at the beginning of the voyage, and to duly care for and carry the goods. While historically some courts, particularly in the U.S. and Anglo-American jurisdictions, had adopted a rather strict liability approach for carriers, the Hague Rules introduced a significant list of carrier immunities under what's broadly known as Article 4.2. These immunities allowed carriers to escape liability for specific events, such as acts of God, perils of the sea, fire, acts of war, strikes, inherent vice of the goods.
Meaning the goods' own defects.
Exactly, inherent problems with the cargo itself. Yeah. Also, insufficient packing by the shipper, latent defects not discoverable by due diligence, and crucially, errors in navigation or management of the ship by the crew. This extensive list gave carriers considerable protection.
That sounds like a pretty extensive list of exceptions, making it quite challenging for cargo owners to claim compensation. And there was also a limitation of liability and a time limit for claims, right?
Yes, exactly. The Hague Rules introduced the concept of limiting the carrier's liability to certain amounts, often calculated per package or per unit of cargo. This was a critical feature as it capped the financial exposure of carriers, and there was a one-year time bar, meaning that cargo interests generally had only 1 year from the date of delivery, or when the goods should have been delivered, to bring an action against the carrier. This was significantly shorter than general contract law statutes of limitation, and it was designed to ensure quick resolution of maritime disputes, reflecting the fast-paced nature of international shipping.
So the Hague Rules set a foundational, though carrier-friendly, baseline. Then came the Hague-Visby Rules in 1968, along with the 1979 SDR Protocol. What did these amendments specifically achieve, and how did they try to update the original rules?
The Hague-Visby Rules were essentially crucial revisions and improvements to the original Hague Rules. They aimed to address some of the ambiguities that had emerged over decades of application and to adapt the rules for modern maritime trade, which had become far more complex. The 1979 SDR protocol was particularly important for liability limits, changing the unit of count from the outdated gold francs to special drawing rights, or SDRs, of the International Monetary Fund. To clarify for you, SDRs are a kind of international reserve asset, a basket of currencies, used by the IMF to provide a more stable and relevant unit for calculating international compensation, countering the effects of inflation on the old gold franc standard.
And these rules gained force of law in many places, right? What does that mean for their application?
Yes, they did. National legislation in many maritime nations, such as the UK's Carriage of Goods by Sea Act 1971, explicitly gave the Hague-Visby rules the force of law. This meant that in specific trades and jurisdictions, these rules applied mandatorily, regardless of what the parties might try to put in their contracts. Their scope remained largely tackle to tackle, like the original Hague rules, but they brought significant improvements in clarity for issues like package limitation and deck cargo. Importantly, under Hague-Visby, the rules apply regardless of whether the contract of carriage is oral or written, or covered by a physical bill of lading or a non-negotiable seaway bill, as long as it's a lading contract that would typically involve a bill of lading or similar document. This widened their practical reach.
What about losing the right to limit liability under Hague-Visby? Is it easier to break the limitation under these updated rules compared to the original Hague rules?
It's still a very, very high bar to break the limitation, which is a key policy objective in maritime law to encourage shipping. Under Hague-Visby, a carrier loses the right to limit liability only if the loss resulted from their personal act or omission committed with the intent to cause such loss or damage, or recklessly and with knowledge that such loss or damage would probably result. This isn't about the fault of an individual crew member. It requires proving a very high degree of fault, specifically intent or recklessness on the part of the carrier as a company, meaning attributable to the highest levels of the company's management, their directing mind and will. It's an extremely stringent test, making it genuinely difficult for claimants to break the limit. This high threshold serves to protect the commercial viability of shipping operations.
Now let's turn to the Hamburg Rules of 1978. These were a much bigger departure, weren't they? They often stir quite a bit of debate.
Indeed, they were. The Hamburg Rules were a direct and deliberate response to widespread criticisms of the Hague Rules, particularly from developing countries with significant cargo interests. These nations felt the Hague Rules were too heavily biased in favor of carriers, failing to provide adequate protection for cargo owners. The Hamburg Rules, therefore, aimed for a far more comprehensive and modern liability regime, intending to rebalance the responsibilities and risks more favorably toward the cargo owner. They represent a significant philosophical shift.
And they significantly widen the scope of the carrier's responsibility, both geographically and in terms of the types of cargo covered.
Yes, dramatically so. Unlike the Hague and Hague-Visby tackle-to-tackle approach, the Hamburg Rules apply if the port of loading or discharge is in a contracting state, or even if the bill of lading is issued in a contracting state. More importantly, they cover the full period goods are in the carrier's custody, from the moment the carrier receives them at the port of loading to the moment they are delivered at the port of discharge, including periods on shore, before loading, and after discharge.
Port to port, essentially.
Exactly, port to port. Furthermore, they explicitly include deck cargo and live animals, which were excluded under the Hague Rules, reflecting a more inclusive view of modern shipping realities. The Hamburg Rules also provide a much broader and clearer definition of the contract of carriage itself, leading to more general application across different types of shipping agreements.
So, a wider geographical and temporal scope. What about the fundamental basis of carrier liability? Was there a shift in how cargo owners prove fault?
This is a key difference and a major win for cargo interests. The Hamburg Rules shift from the Hague's detailed list of immunities to a simple presumed fault principle for carrier liability, under what's generally referred to as Article 5.1. This significantly simplifies the burden of proof for the cargo owner. Instead of having to prove the carrier's specific fault for a specific incident, the carrier is presumed liable for any loss, damage, or delay to the goods unless they can affirmatively prove that they took all reasonable measures to avoid the incident and its consequences. The burden shifts. The carrier has to disprove fault.
And perhaps the most significant difference you mentioned earlier, the removal of the nautical fault exemption. What impact did that fundamental change have?
This is truly a cornerstone of the Hamburg Rules and represents a stark contrast to Hague and Hague-Visby. Under the older rules, carriers were often exempt from liability for errors in navigation or management of the ship, what's known as nautical fault, even if those errors led directly to cargo damage. The Hamburg Rules removed this exemption entirely, making the carrier liable even for these types of fault. This was a major point of contention during negotiations and a significant victory for cargo interests globally. It holds carriers more broadly accountable for the actions of their crew in managing the ship, reflecting a move towards greater carrier responsibility. While the burden of proof for fire still remains on the carrier, this change generally shifted much more responsibility onto the carrier for the entire voyage.
I also understand that the Hamburg rules explicitly address liability for delay in delivery, something the earlier rules were silent on. How do they handle that?
Yes, that's another practical improvement. Unlike Hague and Hague-Visby, which were silent on the matter, the Hamburg rules specifically address liability for delay in delivery. They limit liability for delay to 2.5 times the freight for the delayed goods. However, it's important to note that this cannot exceed the total freight payable for the entire delayed consignment. This provides a clear framework and a cap for compensation in cases of late delivery, which is crucial for predictable trade.
And what about jurisdiction? Does Hamburg offer more flexibility for claimants?
Absolutely. Another significant advantage of the Hamburg rules is that they provide a wide choice of jurisdictions for claimants, often referred to as Article 21. This is a major improvement over the silence of Hague and Hague-Visby on jurisdiction, which often left claimants at the mercy of the carrier's chosen forum, potentially in a distant country far from their own operations or location. Hamburg gives claimants more options, fostering a more equitable playing field.
It sounds like a constant evolution, with clear conflicts existing between these different conventions. How is that managed in practice?
They definitely do conflict. The coexistence of these three distinct conventions, Hague, Hague-Visby, and Hamburg, create significant challenges for uniformity and harmonization in international maritime law. It means that depending on which countries are involved in a shipment and which conventions they have ratified, different rules might apply, leading to legal complexities. International organizations like UN CITROL, the UN Commission on International Trade Law, and various EU commissions have been actively involved in evaluating these rules and preparing reports, continually trying to bridge the gaps and promote greater uniformity in international maritime law. It's a continuous, ongoing effort to find common ground.
How do paramount clauses fit into this complex picture of international rules? Can they override these conventions?
Paramount clauses are contractual provisions typically found in bills of lading or other contracts of carriage. They expressly incorporate the terms of an international convention, like the Hague, Hague-Visby, or Hamburg rules, into the contract, even if those rules wouldn't automatically apply by their own force. They can essentially enlarge the scope of these rules. For example, a paramount clause might extend the application of Hague-Visby beyond its default tackle-to-tackle scope to cover the entire period the goods are in the carrier's custody. This is a way for parties to opt into a particular legal regime, providing more certainty and consistency across their contracts, regardless of the specific port of origin or destination, thereby helping to mitigate some of the complexities arising from the existence of multiple conventions. If the chosen law protects cargo interests more than the law of the court hearing the case, for instance by setting higher liability limits, that chosen law will typically be given effect, as the rules establish minimum liability standards.
Okay, our next chapter is Managing Maritime Risks, General Average, Salvage, and Towage. These concepts truly speak to the inherent dangers and unique challenges of sea travel. Let's start with general average. What's the core, almost ancient idea behind this?
General average is a fascinating and indeed very ancient principle, born from the earliest days of sea travel when risks were immense. The core concept is that if a voluntary sacrifice or an extraordinary expenditure is made by any party involved in a sea venture, be it the ship itself, the cargo it carries, or the freight earned, in order to save the common venture, meaning all property at risk, from an imminent peril, then all parties to that venture must proportionately share in the resulting loss or expense.
So sharing the pain to save the whole enterprise.
Precisely. For example, if a ship is caught in a storm and cargo must be jettisoned to save the ship and the remaining cargo from sinking, the owners of the ship and the remaining cargo must contribute to compensate the owner of the jettisoned cargo. It's truly about sharing the burden of peril for the common good and survival.
And I've heard of Jason and new Jason clauses. How do they relate to general average, especially if the carrier was at fault?
These clauses are crucial additions to contracts of carriage, particularly relevant in the U.S. Historically, if the peril that led to the General Average Act was due to the carrier's fault, the carrier couldn't claim a contribution from the cargo owners for their sacrifices or expenses. The JSON and later new JSON clauses were developed specifically to counteract this, providing a means for ship owners to still claim a general average contribution, even if the peril was caused by their fault, provided they are legally absolved from liability for that fault by law or by the contract itself. This often happens if one of the immunities under laws like Co-GSA applies, excusing the carrier from liability for the initial fault. It's a way to ensure the principle of common sacrifice still operates, keeping the system commercially viable even with an element of carrier fault that is legally excused.
So it's a way to keep the system moving, even when there's an element of fault, provided that fault is legally excused. Are there international rules for how these complex general average adjustments are made?
Yes, absolutely. Given the complexity and international nature of general average, there's a strong need for uniformity in how these contributions are calculated and adjusted. The York-Antwerp rules, often abbreviated as YOR, specifically the YR in 1974, are the internationally recognized standard for adjusting general average contributions. They provide a comprehensive and uniform framework for how these complex calculations and adjustments are to be made, bringing much-needed consistency to what could otherwise be a chaotic and contentious situation. They define what constitutes a general average act and how losses are to be apportioned.
Next, we have salvage operations. This brings to mind heroic rescues at sea, often in dramatic circumstances. What's the legal definition of salvage, and what's the core principle that governs it?
Salvage is defined as a voluntary service rendered to save maritime property, whether it's a ship, its cargo, or even a rig from peril at sea. The key word here is voluntary. If there's a pre-existing contractual duty or a legal obligation to rescue, it's not strictly considered salvage in the legal sense. And the fundamental principle governing salvage is the famous no cure, no pay.
No success, no reward.
Exactly. This means salvers are only rewarded if their efforts are successful in saving property. If they try and fail, they get nothing for their efforts, no matter how valiant. It's a powerful incentive to succeed.
And who ultimately pays for these successful rescues, especially if it's the cargo that's saved?
Any party involved in the common venture, like the cargo interests, whose goods were saved, must pay their proportionate share of the salvage award. It's a shared liability based on the value of what was saved. Now, if salvage services aren't requested by an authorized person, like the master of a vessel, the owner of the salved property isn't liable in personam, meaning personally, but the property itself is liable in rem, meaning against the thing itself. This allows the vessel or cargo to be arrested as security for the award, ensuring the salver can get paid.
What happens if the salver, in the course of their efforts, acts negligently? Can they lose their reward or even be held liable for further damage?
Yes, salver misconduct has very clear and severe consequences. Mere negligence that leads to an unsuccessful salvage operation will result in the total denial of any award, upholding the no cure, no pay principle. If their negligence only reduces the degree of success, their award will be reduced proportionally. However, if a salver is guilty of gross negligence or willful misconduct, they can face severe penalties. Not only total denial or reduction of their award, but also liability for affirmative damages for any loss or damage caused to the salved vessel or cargo. Furthermore, if a salver inflicts a distinguishable or independent injury on the salved vessel, they can be held liable for affirmative damages, even without gross negligence, if that injury is separate from the original peril they were trying to rescue from.
That's a strong incentive for careful and professional action. Given the emergency nature of salvage, how do these agreements typically get formalized so quickly?
In an emergency, there's often no time for lengthy negotiations or drafting complex contracts. That's where the Lloyd's Open Form, or LOF 2000, comes in. It's a highly standardized and widely used salvage agreement specifically designed for emergencies. Its purpose is to provide a quick, simple, and internationally recognized framework for engaging salvage services, allowing salvers to get to work immediately without delay. LOF 2000 streamlined its predecessor, LOF 1995, by moving many procedural rules into separate standard clauses, keeping the main document concise and actionable. It embodies that fundamental no cure, no pay principle while providing a swift, enforceable legal basis for rescue.
And what about the scopic clause? I understand that's a significant addition to the LOF, particularly concerning environmental protection.
The scopic clause, or Special Compensation P&I Club clause, is a very important development and a significant departure from no cure, no pay in certain circumstances. It was added to the LOF to provide guaranteed remuneration to salvers in situations where their efforts are primarily for environmental salvage operations, even if no property is ultimately saved. For example, if a ship is about to break up and spill its oil, salvers might act to prevent pollution, even if they know the ship itself is a total loss. Scopic ensures they get paid for these environmentally crucial actions.
So it encourages action even if the vessel can't be saved.
Exactly. It aims to encourage salvors to undertake potentially unremunerative but environmentally critical actions, like preventing massive oil spills. It outlines specific tariff rates for personnel, tugs, and equipment, ensuring salvors get paid for their efforts, especially when there's an environmental imperative overriding pure property salvage. Disputes under LOF are typically resolved through a specified arbitration process in London, governed by Lloyd's procedural rules, with provisions for appeals and security, ensuring rapid resolution.
Finally, in this chapter, let's talk about towage contracts. How do they differ fundamentally from, say, a contract of affreightment for cargo, and why is that distinction so important?
This distinction is crucial because very different legal liability regimes apply to each. A towage contract involves one party undertaking to move another party's vessel or structure from one place to another. Think of a powerful tugboat moving a large, unpowered barge, or assisting a ship into a crowded port. The tug is providing propulsion and guidance, but the towed vessel remains under the command of its own master, at least to some extent. In contrast, a contract of affreightment is an undertaking to transport cargo from one place to another, where the party providing the service also provides the carrying capacity, like a ship owner carrying goods on their vessel. The ship owner is completely responsible for the safe delivery of the cargo. The specific legal implications and liabilities, particularly regarding responsibility for the vessel being towed versus the cargo being carried, can vary significantly depending on which type of contract is in play. So getting that distinction right in practice is absolutely vital for determining who bears the risk.
Let's navigate into Chapter 4, Navigational Hazards Collisions at Sea. This is one of those dramatic scenarios people often picture when they think of maritime incidents, with potentially catastrophic consequences. What are the core rules that govern preventing these?
The primary international rules designed to prevent collisions are the International Regulations for Preventing Collisions at Sea, 1972, universally known as COLREGs. These are essentially the rules of the road that all mariners must follow to prevent collisions at sea. They're a comprehensive set of regulations covering everything from specific steering and sailing rules, depending on the vessel's situation, to requirements for navigation lights and shapes displayed, and sound signals in various conditions. They dictate how vessels should behave when approaching each other to avoid a dangerous situation.
So, when a collision does happen, despite these rules, how is fault typically determined? What are the various sources of liability that courts or arbitrators will look at?
Liability for collisions can arise from several forms of fault. Firstly, it could be simple negligence or a lack of proper care and skill on the part of the navigators, for example, not keeping a proper lookout. Secondly, a direct violation of the call regs themselves or other applicable national or local rules of navigation is often a primary source of fault. Thirdly, a failure to comply with established local navigational customs or usage, which might be specific to a port or waterway, can also be a factor. And finally, an unseaworthy condition of the vessel itself or an equipment malfunction that contributes to the collision, such as a faulty rudder or radar, would also be a source of fault. All these factors are investigated to establish culpability.
So the test for liability isn't just who hit whom, but a deeper look at the conduct involved, essentially asking if the collision was avoidable.
Precisely. The core question is always, could the collision have been avoided by exercising ordinary care, caution, and maritime skill? Collision cases are incredibly fact-specific and notoriously complex. They require a very detailed analysis of all the circumstances leading up to the incident, including the navigation decisions, communication attempts, or lack thereof, adherence to the call regs and other rules, and general good seamanship to determine the degree of fault attributable to each party. It's rarely a simple single cause.
We discussed this briefly earlier in the context of bills of lading, but let's revisit the both-to-blame collision clause specifically for collision scenarios. Why is it so important for cargo interests?
You're right to highlight it again, as it's directly relevant here. This clause, typically found in bills of lading, is designed for situations where a collision occurs, and both vessels are found to be at fault. In the U.S., for instance, without such a clause, cargo owners whose goods were damaged on a vessel that was partially at fault might be able to recover 100% of their damages from the non-carrying vessel. This clause essentially requires you, as the cargo interest, to contribute proportionally to the damages, even if your carrier is at fault. It's a way to protect the ship owner from bearing the entire burden of cargo claims if another vessel is also negligent. It's a crucial risk allocation mechanism, ensuring that ship owners aren't solely responsible for cargo damage when another ship shares responsibility for the collision.
And how is fault apportioned between the vessels involved? Is it always a simple 50-50 split, or can it be more nuanced?
Not at all. It's rarely 50-50. In the U.S., for example, the Supreme Court's Reliable Transfer Co. case in 1975 established the principle of proportionate fault. This means that liability for the collision is allocated based on the degree of fault attributable to each vessel. If one vessel is determined to be 70% at fault and the other 30%, the damages are typically apportioned accordingly. This approach aims for a more equitable distribution of responsibility. Again, these cases are incredibly fact-specific, requiring detailed investigations and often expert testimony to determine the precise percentages of fault.
Once fault is apportioned, how are damages assessed in collision cases? Are there specific rules for that, or do general legal principles apply?
The sources don't provide specific, unique rules for collision damage assessment that differ radically from other areas of contract law. Instead, general principles for assessing pecuniary loss due to a breach of contract typically apply. This means the party suffering the loss must prove that they actually suffered a financial loss, establish its precise monetary extent, and demonstrate that the loss was a direct and foreseeable consequence of the collision. It's about restoring the injured party to the financial position they would have been in had the collision not occurred, covering things like repair costs, loss of use, and lost profits.
Now to Chapter 5, Protecting Our Oceans, Pollution, and the Environment. This is an increasingly critical and high-stakes area of maritime law, given the potential for devastating environmental damage from shipping incidents. Why has this become such a central focus?
It truly has become paramount. The consequences of maritime pollution, particularly from oil spills, can be catastrophic, impacting fragile marine ecosystems, decimating fishing industries, harming coastal tourism, and affecting public health for decades. Given that vast amounts of oil and other hazardous substances are transported by sea daily, maritime law has had to evolve significantly to address these immense risks and to hold polluters strictly accountable. It's a global imperative.
Let's start with a major piece of U.S. legislation, the U.S. Oil Pollution Act of 1990, or OPA 90. What's its background and its impact on liability for spills in U.S. waters?
OPA 90 was enacted in the United States largely in direct response to several major, high-profile oil spills that shocked the nation, most notably the Exxon Valdez incident in Alaska in 1989. It is a very stringent and comprehensive piece of legislation. It established a strict liability regime for vessel owners and operators regarding oil discharge into navigable U.S. waters. Strict liability is a crucial legal concept here. It means that liability for damages and cleanup costs can be imposed regardless of fault or negligence.
Regardless of fault. Wow.
Exactly. If there's an oil discharge, the liable party is responsible, full stop. You don't have to prove they were careless. The discharge itself triggers liability.
And what does that liability cover? Is it just the immediate cleanup costs, or does it extend further?
No. OP90's scope of liability extends far beyond just the immediate cleanup costs. It comprehensively includes damages for natural resource damages, meaning the harm done to public resources like fish, wildlife, habitat, and recreational areas. This can include long-term environmental restoration projects. It also provides for private parties to recover damages they suffer due to an oil spill, such as economic losses for fishermen or tourism operators. It's a very powerful and wide-ranging piece of legislation designed to ensure robust accountability and compensation for the full spectrum of oil spill impacts.
Are there broader international efforts to address pollution beyond specific cargo oil spills, perhaps covering fuel or other types of waste?
Yes, there absolutely are, demonstrating a global recognition of this threat. An excellent example of international efforts is the International Convention on Civil Liability for Bunker Oil Pollution Damage, often simply called the Bunker Convention. While OP90 primarily focuses on oil being carried as cargo, the Bunker Convention specifically addresses pollution caused by bunker oil, which is the heavy fuel used to power ships, even when it's not the cargo being transported. This highlights the global recognition that all forms of maritime pollution, regardless of source, need specific legal frameworks to ensure accountability and response. Other crucial international agreements include the Civil Liability for Oil Pollution Damage 1969, CLC, and the Fund Convention 1971, which provide a two-tier compensation system for oil spills, and the comprehensive ARR-BALA 7378 protocols, which deal with the prevention of pollution by ships from various operational and accidental discharges, including waste and sewage. These international efforts underscore a collective and evolving commitment to protecting the marine environment. demonstrating that environmental protection is a shared responsibility across borders with significant legal teeth.
Okay, our next big topic is who pays and how much. Ship owners' limitation of liability and passengers' rights. This limitation of liability sounds like a core concept in shipping, almost counterintuitive given the potential for large-scale disasters. What's the rationale behind it?
It is indeed a universal concept, found in virtually all shipping nations and deeply embedded in maritime legal history. The rationale stems from the inherently perilous nature of maritime transport, particularly in historical contexts. Operating a vessel carries immense and often unpredictable risks: violent storms, hidden shoals, collisions, fires, and other unforeseen catastrophic events. Without some form of liability limitation, the potential financial exposure for ship owners could be so vast and ruinous that it would effectively stifle maritime commerce entirely, making it too risky to invest in ships and global trade. So it's designed to strike a delicate balance, encouraging vital global trade by capping financial exposure while still providing some level of compensation for victims. It's about commercial viability.
So, it's a way to cap the financial exposure and keep the industry afloat. How did this concept evolve historically across different legal traditions?
Historically, there were different approaches to this concept. In common law traditions, like the U.S., limitation of liability was often statute-based, introduced through specific legislative acts. In civil law jurisdictions, it's an even more ancient concept, dating back perhaps as far as the 11th century, where the limitation fund was often based on the value of the ship after the incident that caused the liability. There were various theories, like abandonment, where the owner could abandon the vessel to limit their liability, or execution theories related to a ship's value. But the fundamental idea was always the same. While the ship owner was personally liable for their actions, there needed to be a mechanism to limit that liability to a finite, manageable amount in the face of potentially overwhelming losses.
So, a long and varied history. Which are the key modern international conventions that govern this limitation of liability today?
The most dominant modern conventions are the International Convention relating to the limitation of liability of owners of seagoing ships, 1957, and more significantly, the International Convention on Limitation of Liability for Maritime Claims, 1976, as substantially amended by its 1996 protocol. These are the frameworks that largely define internationally who can limit liability, what types of claims are subject to limitation, and critically, how the limitation fund is calculated. The 1976 convention, especially with its 1996 protocol, is the one most widely enforced globally today, providing significantly higher limits than its predecessor.
Who exactly can limit their liability under these modern conventions? Is it just the ship owner in the traditional sense?
The definition of ship owner for limitation purposes is quite broad under these conventions, reflecting the complexity of modern shipping. It includes not only the actual registered owner of the vessel, but also charterers, whether bareboat, time, or voyage charterers, as well as managers and operators of the vessel. In essence, anyone who is in commercial control of the ship. Importantly, salvers can also limit their liability under these rules, acknowledging the significant risks they undertake in rescue operations.
And what types of claims are subject to this limitation? Does it cover everything?
A wide range of claims are covered, but not absolutely everything. It typically includes claims for loss of life or personal injury, claims for property damage, such as damage to other ships, cargo, or port facilities, claims arising from the infringement of non-contractual rights directly related to ship operations or salvage, claims related to the raising, removal, or destruction of sunken ships or cargo, and even claims by persons other than the liable party, such as insurers who have paid out. It aims to cover most claims that could arise from a maritime incident involving the ship or its operations, but generally excludes claims for pollution from oil, which have their own specific conventions with potentially higher limits, and claims for salvage operations themselves.
How is the actual limitation fund calculated? Is it a fixed amount or does it vary?
The limitation fund is not a fixed amount. It's calculated based on the ship's tonnage, using units of account, which are SDRs, or special drawing rights, as we discussed earlier, that stable basket of currencies. The conventions establish tiered calculations to determine the exact fund. For claims involving loss of life or personal injury, there's a base amount for ships up to a certain tonnage, and then additional amounts per ton for larger vessels, with different tiers for increasing tonnage. For all other claims, for example, property damage, a similar tonnage-based calculation applies, but usually at a lower rate per ton. For example, under the 1976 convention, a ship not exceeding 500 tons has a limit of 333,000 units of account for personal injury claims, while larger vessels have progressively higher but still capped limits. This ensures that the cap scales with the size and potential impact of the vessel.
So it's not just a flat rate. And the most critical question, under what specific, very difficult circumstances can the right to limit liability actually be broken? It sounds like it's exceptionally difficult.
It is extremely difficult to break the right to limit liability under these conventions, and this is by design. The bar is set exceptionally high to maintain the predictability and commercial viability of shipping. A party will only lose the right to limit if it's proven that the loss resulted from their, quote, personal act or omission, committed with the intent to cause such loss, or recklessly and with knowledge that such loss would probably result. This isn't about the negligence of a single crew member on board. It means proving a very high degree of fault, specifically intent to cause the loss, or a very high level of recklessness, and that this fault is attributable to the directing mind of the company, the shipowner or operator's highest level management. This high threshold is fundamental to the underlying policy of encouraging maritime trade by ensuring predictable financial exposure.
Finally, what about passengers' rights? Do they have a separate, specific convention governing their claims for loss or injury at sea?
Yes, they do. The Athens Convention of 1974, as amended by its protocols, particularly the 2002 protocol, specifically deals with the carriage of passengers and their luggage by sea. It sets out a detailed liability regime for carriers in relation to passenger claims arising from loss of life, personal injury, or damage to luggage. While general limitation conventions exist, the Athens Convention provides a specific and, crucially, significantly higher limit for claims arising from loss of life or personal injury to passengers, an amount of 175,000 units of account multiplied by the number of passengers which the ship is authorized to carry according to the ship's certificate. This provides a very specific and substantially higher limit for passenger claims compared to general cargo or property damage, reflecting a greater emphasis on passenger safety and compensation.
Let's turn our attention to Chapter 7, Resolving Disputes from Courtroom to Negotiation Table. Given the complexity, the vast sums of money involved, and the international nature of maritime law, effective dispute resolution must be absolutely indispensable, right?
It's not just indispensable, it's the bedrock upon which the entire global maritime sector functions. The smooth operation and enforcement of rights, the very trust needed to move billions of dollars in goods across borders, fundamentally relies on robust, efficient, and predictable dispute resolution mechanisms. With so many diverse parties involved, shippers, carriers, insurers, banks across countless jurisdictions, without clear pathways to resolve disagreements, the entire system would simply grind to a halt due to unresolved conflicts and legal uncertainty.
What's the spectrum of methods typically used to resolve these complex maritime disputes?
We see a range of methods, broadly categorized. There's traditional litigation in courts, which is certainly an option, but there's also arbitration, mediation, negotiation, and conciliation. There's been a noticeable and growing shift towards alternative dispute resolution ADR methods, primarily arbitration and mediation, precisely because of efficiency concerns, confidentiality needs, and the desire for specialized expertise that often aren't found in traditional court systems.
And the importance of crystal clear jurisdiction clauses in maritime contracts. How crucial are these for avoiding future headaches?
They are paramount, truly non-negotiable for smart players. Including clear law and jurisdiction clauses in maritime contracts and bills of lading is absolutely critical. These clauses provide certainty by stipulating precisely which national law will govern the contract and, just as crucially, which specific court or arbitration forum will have the authority to hear and adjudicate any disputes that arise under the contract. Without this clarity, parties could face unnecessary expenses, prolonged legal battles, and conflicting judgments, just trying to figure out where and under what law their dispute should be heard. Such agreements are generally binding, and courts will typically apply the chosen foreign law, assuming it aligns with public policy.
Let's talk about litigation in admiralty courts, particularly in the U.S., as an example. How does one even get a case into an admiralty court, and what makes these courts unique?
In the U.S., federal courts have specific admiralty jurisdiction, which is quite unique. For tort civil wrongs that cause harm, this typically requires both a locus test, meaning the tortious act must have occurred on navigable waters, and a nexus test, which asks if the activity had a potentially disruptive effect on maritime commerce and was substantially related to traditional maritime activity. For contract cases, the contract itself must be maritime in nature, such as a contract for carriage of goods by sea or a salvage agreement. If there are multiple bases for jurisdiction, a litigant might sometimes choose to invoke diversity jurisdiction, instead of admiralty jurisdiction to secure the right to a jury trial, as admiralty cases typically don't have juries.
No jury trial usually.
Yeah.
Interesting. And what's the fundamental difference between in rem and in personam actions, which sound like very distinct approaches in admiralty law?
This is a fundamental distinction in admiralty, and crucial for understanding how parties can secure claims. An in rem action is brought directly against the property itself, typically the vessel. This is done by arresting the vessel, effectively seizing it, to gain security for a claim. It essentially says, this ship owes me money. This action doesn't necessarily depend on the personal liability of the owner. The claim attaches to the ship.
Against the thing itself.
Exactly. An in personam action, by contrast, is brought against the person, the individual or company who is personally liable for the claim. This is typically done via attachment of assets or garnishment of funds. While there's a quasi-in rem procedure that allows the arrest of a vessel as security for an in personam claim, it's important to note that cargo interests are generally not permitted to file an in rem action against the ship itself for cargo loss. Rather, they sue the person who benefits from the vessel in maritime commerce, like the carrier.
From the courtroom, let's move to arbitration, which seems to be the preferred route for many in maritime disputes. Why is it so highly favored over traditional litigation?
Arbitration is indeed highly favored due to several key advantages that align perfectly with the needs of the maritime industry. First, its flexibility. Parties can tailor the arbitration process to their specific dispute. Second, confidentiality. Unlike public court proceedings, arbitration is private, which is crucial for protecting commercially sensitive information. And perhaps most importantly, the ability to choose arbitrators with specialized maritime expertise. This specialization means disputes are heard by individuals who deeply understand the nuances, customs, and technicalities of the industry, leading to more practical, informed, and often faster decisions than a general court judge might provide.
And where are the main arbitration hubs for maritime disputes globally? Are there particular centers of excellence?
Globally, three major hubs stand out. London is preeminent, with the London Maritime Arbitrators Association, LMAA, founded in 1960. The LMAA provides a widely respected and constantly updated framework for a vast array of disputes, including charter party claims, cargo claims, shipbuilding disputes, repair cases, and complex offshore industry issues. Their LMAA terms, such as the 2021 edition, outline clear procedural rules that promote efficiency. The UK's English Arbitration Act 1996 further supports this, aiming to ensure fair resolution of disputes without unnecessary delay or expense.
And in the U.S., is there a similar prominent body?
In New York, we have the Society of Maritime Arbitrators, SMA. They have well-established rules for both sole arbitrators and tripartite panels, depending on the complexity and value of the dispute. They also specify clear fee structures and outline how costs are assessed, aiming for transparency. SMA awards are considered final, though arbitrators can correct clerical or arithmetical errors. It's important to remember that arbitration agreements generally must be in writing, though in some cases, unreserved participation in the arbitration process can sometimes remedy the absence of a formal written agreement, making it binding nonetheless.
And what about Asia? Is there a rising star in that region for maritime arbitration?
Absolutely. Singapore has emerged as a significant and increasingly popular hub, particularly with the Singapore Chamber of Maritime Arbitration, SCMA. The SCMA offers a cost-effective platform, notably with no filing, administration, or management fees, which can be a huge draw. They also have specialized procedures for specific types of claims, such as bunker claims or collision disputes, making their process very responsive to user needs. Their growth further solidifies arbitration's indispensable role in global maritime dispute resolution, offering yet another expert and efficient forum.
Let's shift to mediation. How does it compare to arbitration, and what are its core advantages?
Mediation is a distinct and highly valuable process that differs from arbitration in a fundamental way. It's fundamentally voluntary, meaning parties agree to seek resolution with a neutral third party, the mediator. Crucially, parties are free to abandon the process at any point until a settlement agreement is formally signed. Once signed, however, it becomes a binding contract. A key principle is absolute confidentiality. Any information shared during mediation generally cannot be disclosed to outside parties or used in subsequent litigation, which is vital for protecting commercial interests. Agreements can extend this confidentiality to third parties present during the process.
What's the mediator's role, since they're not making a judgment like an arbitrator?
The mediator's function is not to impose a solution or make a ruling. Instead, their role is to facilitate communication between the parties, helping them to explore different perspectives, understand each other's interests, and ultimately work collaboratively towards mutually acceptable solutions that meet their commercial needs. There are different approaches: facilitative mediation, where parties lead the discussion; evaluative mediation, where the mediator might assess legal positions and offer opinions; and directive mediation, where the mediator more actively guides the solution. In some jurisdictions, like Greece, a mediation agreement, once signed, can even be declared enforceable, much like a court judgment, upon the request of just one party, giving it legal weight.
This all sounds efficient, but what about time barring of claims? Are there strict deadlines for bringing these types of cases in maritime law?
Absolutely. Time barring, or limitation periods, are a critical feature. These are mandatory rules designed to provide certainty, promote prompt resolution, and prevent evidence from disappearing over time. This is critical in the fast-moving world of maritime commerce. For instance, the Hague and Hague-Visby rules typically impose a relatively short one-year limitation period for bringing actions against carriers.
So what about claims for indemnity or recourse actions, where one party seeks compensation from another after having settled a claim themselves? Are those deadlines different?
Yes, recourse actions, where one party seeks indemnity from another after settling a claim, often have special, even shorter limitation periods. For example, under the Hamburg rules, it's typically 90 days, and under Hague-Visby, it's 3 months. These periods typically start from the day the parties settled the claim or was served with process in the action against themselves, not from the date of the original incident. The general rule for the primary limitation period for an action against the carrier usually commences on the day goods were delivered or should have been delivered. These short time limits reinforce the industry's need for swift finality.
Finally, how are damages and costs assessed in these maritime disputes? What does a party need to prove to receive compensation?
To claim damages, the cargo interest, or the injured party, must prove they suffered actual pecuniary contractual loss, directly resulting from a breach of contract or an actionable wrong. Pecuniary contractual loss simply means a financial loss that can be quantified. This loss must have been foreseeable by a prudent carrier at the time the contract was made, or explicitly communicated to the carrier if it involves special or subjective value of the goods. In cases of physical damage, the causation of loss is usually quite apparent. However, for non-physical loss like delay in delivery, the cargo interest has to prove that expected benefits or profits from the goods dropped directly due to the breach. As a general principle regarding costs, court costs often follow the liability cause, meaning the party whose actions led to the unjustified litigation is typically obliged to pay the reasonable expenses of the other side. This encourages responsible conduct and discouraging frivolous claims.
And just like that, we've truly navigated the complex, yet absolutely fascinating waters of maritime law. We journeyed from the foundational bill of lading, unpacking its triple function as a contract, a receipt, and that crucial revolutionary document of title. We explored the intricacies of mates receipts and understood how charter party bills of lading can legally transform from simple receipts into full-fledged contracts under laws like COD-GSA when transferred to third parties.
We certainly did. We charted the remarkable evolution of international conventions, tracing the initial compromise of the Hague Rules with their tackle-to-tackle scope and extensive carrier immunities. We saw how the Hague-Visby Rules refined that, introducing SDRs for modern liability limits. And we examined the true paradigm shift brought by the Hamburg Rules, with their wider scope, their presumed fault principle, and that game-changing removal of the nautical fault exemption, illustrating the ongoing struggle for balance between cargo and carrier interests, sometimes aided by paramount clauses.
Then we explored how risks are managed on the high seas, delving into the ancient principle of general average, that idea of shared sacrifice for common survival, and its modern adaptations like the new Jason clauses. We highlighted the critical role of salvage operations, governed by the no cure, no pay principle, and the standardized Lloyd's Open Form 2000, alongside the absolutely vital environmental lifeline of the scopic clause. We also distinguished towage contracts from contracts of affreightment, clarifying their differing liabilities.
And we didn't shy away from the dangers, examining collisions at sea, guided by the international rules of the road, CAL-REGs, and understanding how fault is apportioned and damage is assessed under principles like proportionate fault. We then moved to the increasingly vital area of pollution and the environment, specifically highlighting the stringent, strict liability of the U.S. Oil Pollution Act 1990 and broader international efforts like the Bunker Convention and MARPOL, which are safeguarding our precious oceans.
Finally, we unpacked the crucial concept of shipowners' limitation of liability, a universal principle that balances risk with the very commercial viability of global trade, focusing on the 1976 convention and its extraordinarily high bar for breaking that limitation. We also touched upon passengers' rights under the Athens Convention and circled back to the essential mechanisms for dispute resolution, from litigation in specialized admiralty courts, understanding the difference between in rem and in personam actions, to the preferred avenues of arbitration in London, New York, and Singapore, and the collaborative potential of mediation, all while battling the ever-present challenge of strict time barring for claims.
What's clear, if anything, is that maritime law isn't just a collection of dusty old rules confined to history books. It is the invisible yet utterly indispensable foundation for safe, fair, and environmentally responsible global commerce. Without these intricate rules and the robust mechanisms for their enforcement, the world's complex supply chains, from your morning coffee to your computer, would simply grind to a halt. It's a testament to continuous international cooperation and adaptation, a living body of law that constantly evolves with the dynamic nature of the seas.
Indeed, it's a field that's always in motion, so consider this provocative thought. In an increasingly interconnected and digital world where shipping routes are optimized by AI and physical documents like bills of lading are rapidly being replaced by electronic data and blockchain, how might the ancient principles of maritime law continue to evolve to maintain that delicate balance between carrier liability and global trade efficiency, and what entirely new risks might emerge from these profound technological shifts?
A truly fascinating question for the future of global commerce. For those of you eager to dive even deeper into these waters, we've extracted some excellent resources from our sources for your continued exploration. First, some key textbooks and legal commentaries. We'd suggest looking at Carriage of Goods by Sea by Carver, T.G. Also, Marine Cargo Claims by William Tetley. Then there's Payne and Iveme's Carriage of Goods by Sea. And for a broader view, Admiralty and Maritime Law by Force and Yiannopoulos. And specifically on limitation on liability for maritime claims by Patrick Griggs and others.
Great list. And any notable organizations or journals?
Definitely. Keep an eye on the Lloyd's Maritime and Commercial Law Quarterly, often called LMCLQ. Also, the Journal of Maritime Law and Commerce, JMLC. And of course, the websites for the main arbitration bodies are invaluable. The London Maritime Arbitrators Association, LMAA, the Society of Maritime Arbitrators, SMA in New York, and the Singapore Chamber of Maritime Arbitration, SCMA.
Excellent resources. Thank you for joining us on this deep dive into maritime law. We hope you feel much more informed and ready to navigate these legal waters yourself.